Welcome to this explainer. Okay, let's dive right in. Today, we're unpacking a truly fascinating piece of source material, a 2003 judgment from the Constitutional Court of South Africa. We're going to explore a bizarre legal puzzle, a real-world catch-22, where a major civil rights victory was almost completely erased by a simple, routine bureaucratic update. It's a story about the rigid rules of law, the human need for justice, and how a court managed to untangle an absolutely impossible knot. Think about this predicament for a second. You fight a long, exhausting legal battle, you win. But right before the ink even dries on your final victory, the government essentially hits delete on the law you just defeated and replaces it with a new one. Well, this is the exact trap Judge Kathleen Satchwell found herself in. She was fighting for equal financial and travel benefits for her same-sex partner, and her journey through the courts perfectly highlights that intense friction between strict legal procedures and everyday common sense. Let's start with Section 1, a hollow legal victory. Our story kicks off in the Pretoria High Court back in 2001. Judge Satchwell originally secured an order of constitutional invalidity regarding Sections 8 and 9 of the 1989 Judges' Remuneration and Conditions of Employment Act, as well as some related 1995 regulations. She successfully argued that this legislation was unconstitutional because it unfairly discriminated on the basis of sexual orientation and marital status. And this is a crucial reminder of why these cases matter so much. Literally, a single word in a law can exclude entire groups of people from foundational rights. Let's look at exactly what was happening. The 1989 legislation blatantly conferred specific financial and travel benefits upon the spouses of judges. But if a judge had a permanent same-sex life partner, well, that partner was left out completely. They got absolutely nothing. The High Court agreed with Judge Satchwell that this exclusion was totally unfair and unconstitutional. So she won, right? Well, not quite yet. You see, in the South African legal system, there's a very specific two-step process. A high court can declare a parliamentary law invalid, sure, but that order has absolutely no force. It legally means nothing until it goes through confirmation proceedings at the Constitutional Court. You've got to complete step 2 for the victory to actually be real. Which brings us to Section 2, the bureaucratic loophole. This is the incredible twist that nearly derailed the entire case. The High Court invalidates the 1989 Act in 2001. But before her victory could be confirmed by the Constitutional Court in July 2002, the legislature acted. In November 2001, the 1989 Act was completely repealed and replaced by the brand new 2001 Judges' Remuneration and Conditions of Employment Act. The rug was literally pulled out from under the case while it was just waiting in line. So the crucial point here is the sheer agonizing consequence of this timeline. When the Constitutional Court finally issued its confirmation order in July 2002, validating her win, it was confirming the invalidity of a law that technically no longer existed. Because the 1989 Act had been repealed months earlier, her hard-fought victory was effectively rendered hollow. Imagine fighting that entire battle, winning, and gaining absolutely no effective relief whatsoever. Just brutal. And to make matters incredibly frustrating, and frankly a little absurd, the brand new 2001 Act did make some updates, like including constitutional court judges in its scope. But then, the government literally copy-pasted the exact same discriminatory language from the old law. It still explicitly afforded benefits only to spouses and completely ignored permanent same-sex life partners. A brand new law, but the exact same old discrimination. At this point, you really have to wonder, why couldn't the justice system just use a little common sense here? If the old law was unconstitutional and the new law says the exact same thing, why couldn't the Constitutional Court just update the paperwork, swap out the 1989 Act for the 2001 Act in their ruling, and call it a day? Well, the answer lies in the strict boundaries of legal jurisdiction. As Justice O'Regan points out in the judgment, confirmation proceedings are, by their very nature, concerned only with the specific legislation that has already been declared inconsistent by a lower court. The Constitutional Court's hands were completely tied. They just can't evaluate statutory provisions that weren't in front of the High Court. Trying to alter their own order to target the new law, that was a total non-starter. This left the applicant facing the exhausting prospect of starting a years-long trial all over again in the lower courts, just to challenge the new identical law. So what happens next? Let's move to Section 3, the direct access shortcut. Desperately needing a procedural shortcut, Judge Satchwell applied for something called direct access under Rule 17. This is a very rare and powerful legal mechanism. Essentially, it allows an applicant to skip the High Court entirely and approach the Constitutional Court directly, making it the court of both first and final instance. It acts as a much-needed safety valve for exactly this kind of bureaucratic nightmare. Now, courts don't just hand this out to anyone who asks. To grant direct access, the court looks at a very strict checklist to ensure it's truly in the interests of justice. They ask things like, is there a dispute of fact? Have other courts already properly traversed these issues? What is the attitude of the opposing parties? And how undesirable is further delay? The court has to carefully balance its rigid procedural rules against the desperate need for immediate justice. Fortunately, Judge Satchwell's case ticked every single box perfectly. The constitutional issues were identical. They'd already been thoroughly traversed. And crucially, the Minister of Justice and Constitutional Development actually filed a notice stating he did not intend to oppose the application. So no dispute of fact. Because of this momentum, the court agreed that refusing direct access would cause immense inconvenience and an unjustifiable delay in giving her the relief she was legally entitled to. Moving right along to Section 4, unfair discrimination. The applicant was now able to formally challenge the specific problem areas of the new legislation. This included Sections 9 and 10 of the 2001 Act, which dealt with pensions and gratuities for surviving spouses, and the newly amended 2002 regulations governing travel and subsistence allowances. And it's important to remember, these aren't just dry legal terms. We're talking about pensions and travel allowances that dictate a couple's livelihood, their financial security, and their everyday quality of life. The ruling was swift and decisive. Justice O'Regan confirmed that, just like the previous 1989 Act, there was absolutely no justification for this new 2001 legislation to discriminate. Failing to afford these benefits to permanent same-sex life partners who have undertaken reciprocal duties of support is unfairly discriminatory based on sexual orientation and marital status. The new laws were just as unconstitutional as the old ones, so they won again. But the question remains, how do you prevent another loophole? How do you fix a broken law instantly? Let's look at Section 5, rewriting the law. To ensure this victory wasn't hollow a second time, the Constitutional Court didn't just strike the law down and tell Parliament to try again. Instead, they utilized a very powerful constitutional remedy called reading in. Reading in is exactly what it sounds like, and it works almost like a legal superpower. It's a remedy where the court cures the unconstitutionality of a statute by literally inserting missing words directly into the text of the law itself. So the court ordered that this exact phrasing, or partner, in a permanent same-sex life partnership in which the partners have undertaken reciprocal duties of support, be permanently read into the 2001 Act and the 2002 regulations. The final result was immediate. Wherever the word spouse appeared in those specific sections and regulations, the new phrase was instantly tacked on right after it. With one stroke of the judicial pen, the law was literally rewritten to immediately grant same-sex partners the exact same financial, pension, and travel benefits as married spouses. The Catch-22 was finally officially defeated. This case really shows us a moment where bureaucracy created an impossible looping trap. But it also reminds us that the law has safety valves. When you have the right constitutional tools, like direct access to cut through the red tape and reading in to fix the text instantly, you can ensure that justice isn't just a hollow victory on a piece of paper, but a real, tangible outcome. But it leaves us with this final thought to ponder. If the government can just rewrite the rules mid-game, how many other vital rights are currently trapped in a bureaucratic loophole, just waiting for the right constitutional tool to set them free? Thanks for joining me on this explainer.